Good afternoon, everyone, and welcome to Gowling WLG's first ever IT Masterclass by webinar. We're very pleased you could all join us this afternoon when we're going to be talking on a range of topics, broadly along the theme of what's been happening in the last 6 months since GDPR went live on the 25th of May. My name's Jocelyn Paulley. I am a data protection and IT specialist, and I'll be looking at some of the common implementation issues that we saw clients experience, and then have a brief look at data protection in the context of Brexit toward the end.
And you've also got Rocio de la Cruz. I am a data protection and information law lawyer here at the firm. And during the last year, I've been helping clients on the implementation and development on the data protection regime. And I will cover the importance of looking at the Data Protection Act and the GDPR together.
And I'm Helen Davenport, a director at Gowling WLG, and I help clients with contentious data privacy issues and also technology disputes. And I'll be speaking today on dealing with data breaches following the GDPR. A few housekeeping points before we get started. We have allowed some time at the end for questions, so as we're going through, please ask as many questions as you have through the webinar platform, and we'll answer as many as we can at the end. Secondly, as Jocelyn has said, this is the first time we've done an IT Masterclass webinar. Hopefully, many of you will have attended one of our IT Masterclasses at our Birmingham and London offices that we've now been running for over 10 years. At the end of this session, we would be grateful of your feedback on this new format, and we also already have IT Masterclasses in the traditional format planned for January 2019. So if there's anything you would particularly like us to cover in that session, please let us know that too. Having covered those points, I'll now hand over to Jocelyn to talk about common implementation issues.
So what have we been finding since the 25th of May? Well, happily, there were those companies who were well organised and had completed their compliance programs by the date that the legislation came into force. So congratulations to those. There are, however, still a substantial number who were not ready at the date, who are working through compliance regimes and in a risk-based fashion addressing the points in order of priority. And certainly if you are in that camp, you should certainly keep working towards your dates and your roles, and to keep the program going in line with what you had committed to do. It's not all plain sailing though, I think, for those who are now into business as usual privacy governance. Some clients are finding that the project team who had been assembled for the compliance program, once they have dispersed, the new people in roles such as privacy manager and data protection officers are having some trouble picking up the reins from those projects. Maybe documents weren't stored centrally and have been dispersed, or knowledge about decisions and why they were made weren't documented, so it would be easy for those following them to pick up and run with and manage afterwards. Other companies are coming back to look at broader governance issues that they identified in the course of their GDPR compliance. Often companies found that to truly address issues such as implementation of subject access rights and deletion of documents and document retention, what was really required for a slick solution was a broader document management or information management regime and software and procedures, so that it was easier to find and locate information, easier to search through it, easier to set rules around deletion and retention. And that's clearly a much bigger project requiring more and potentially different resource and money to purely focusing on data protection issues. Some companies are entering what I've termed a phase 2 compliance regime. So by that I mean that they crossed the finish line for the key issues that needed to be addressed for the 25th of May, and are now coming back to look at some issues again in more detail. Maybe that's because they were trickier issues, or because the time and resource wasn't there at the point at which they did the program, and now they are coming back to focus on those.
And just what are these challenging areas that you've been dealing with during this time?
I think it depended to a certain extent on which sector clients were in. Different sectors had different particular issues, but I think there were some common issues across clients that we were advising. One of those was around retention of emails. This goes back to a document management system, as I was just mentioning. If one of those is not in place, it's much harder to decide how to deal with emails. If companies live in their inboxes and that's effectively used as a storage solution, it's much, much harder to see how you can break down retention of emails when you start to think of them not as emails but as different categories of personal data. Similarly with destruction, if you have managed to set a policy around how long different pieces of data need to be kept for, it's still a different matter actually implementing rules around making sure those items of data are deleted at the time that you said they would be. And again, doing that requires assistance from an IT department and understanding where document is kept to be able to set those kinds of rules. Many businesses, I think, are still engaging with the issue of privacy managers or champions or data protection officers, whatever label you've given them, and depending on whether or not there's a mandatory requirement for a DPO. Clearly in some countries, such as Germany, data protection officers have been in place for some time, and there is a ready-made set of people with that skill set. That's not the case in the UK, and I think there has been, as we anticipated there might be, a shortage of that skill set in the market. So many companies I know are using existing people and building on their knowledge within an organisation. I think though there is still a challenge in people taking on a new role alongside what was probably already a full-time role, and putting in place new escalations, new reporting lines, and making sure that those work fluidly and easily, particularly difficult when many people in that reporting line might be new. In a similar vein, the idea of training the business in order to be compliant with the accountability principles in GDPR. Anyone in the business handling personal data clearly needs to be trained in what the legislation says and what they should and shouldn't be doing. Many compliance programs obviously addressed this, and it's all very well doing training as a one-off activity as the legislation comes into force, but clearly that needs to be refreshed on an ongoing basis and also rolled out to new starters. It also needs to get over the difficulties of disparate geographical locations of businesses, say if you're a retailer with lots of outlets, and across geographies as well, dealing with different languages. And auditing processes and those handling personal data for you, I think is a difficult issue because of the scale of the task, and also knowing what the right approach is, what are the questions that should be asked, and what are the responses that you're actually looking for, and if you get a response you feel isn't sufficient, how do you then take that forward?
And do you think there are solutions in the market that can help organizations within their compliance plans?
That is a really common question that we're seeing about whether software can help with compliance. And I think auditing processes is one area where it can, but it is quite a complex area. There are, if you've been looking, I'm sure you're aware, a plethora of software solutions out there now, all claiming they can help you become GDPR compliant or just help with the process. We've had a look at some of them, and I think the difficulty is that different software programs address different aspects of GDPR compliance. Some might be fantastic auditing tools, so you can see that a flag was raised, an action was assigned, someone dealt with it. Some might be great for data flow mapping, some might be just repositories, others might help with disclosure of subject access requests and redaction. But I don't think there is a single silver bullet that can help with the whole regime. I think you have to understand what your particular needs are and therefore find some software to assist with it. I do think, though, it isn't something that can help when it comes to auditing processes. I think that's very much looking from the point of view of, if you are a processor, save all of your clients and customers coming to you and asking you, please give us information to show that you're GDPR compliant. I have seen some companies using dashboards in a really effective way to present all that information to their customers. So it's effectively a help yourself library where you can go in, look through the documentation that's available and make your own assessment about GDPR compliance. Certainly, I think to help address the training challenge that I mentioned, software in terms of e-learning or modular-based resources are very useful for an ongoing training program as new people join a business and for refresher training. It obviously also has the added benefit of auditability because you can tell who has taken the training and at what time. There are some problems, of course, that the software can't help with, one of those being recruitment of data protection officers, as I mentioned earlier. You do get virtual DPO resources offered as a service by some companies, although clearly that's just facilitated by software, it's not the software itself. But there's certainly a role for humans here and something that we will have to do on our own just with the assistance of the software. So now I'm going to hand over to Rocio, who's going to talk about the Data Protection Act 2018, given that that came out just as the GDPR came into force.
Thank you, Jos. So indeed, the Data Protection Act is an important piece of legislation that you need to consider along with GDPR. So the important thing is to bear in mind that you need to apply both together. And remember that the data protection regime is covered by different pieces of legislation. So there is a right to data protection, which, as you know, is a fundamental right. And then applicable in the UK, we've got the General Data Protection Regulation, GDPR. We've got the Data Protection Act 2018. And we also have other regulations, for example, relevant to marketing communications. We've got the Privacy and Electronic Communications Regulations 2003, and then we are expecting a new e-privacy regulation and possibly a similar regime in the UK if this comes into force after Brexit. So definitely different pieces of legislation that we need to look at.
So what's the first thing that organisations should be looking at within the Data Protection Act 2018, Rocio, in your view?
Right. So as you can see in the slide, the Data Protection Act covers different parts. So we can say that there are 4 different regimes, including in one sole act. So we have the general processing, which is in part 2, which also covers other processing which is not covered under GDPR, but we are implementing here in the UK, for example, for the processing of unstructured manual data used by public bodies which are subject to the Freedom of Information Act. So all of that is covered in part 2. And then we've got part 3 dealing with law enforcement, part 4 dealing with the processing of personal data by the intelligence services. Relevant to the general businesses, in addition to part 2, are the schedules 1 to 19, and in particular the additional grounds and exceptions. And these additional grounds, Helen, is what is the first thing to look at to make sure that you are processing personal data legally. And just a recall, you know that to process any type of personal data, you need to look at Article 6 of GDPR. And we are talking about different legal bases here, like consent, or if it is necessary to perform a contract, to comply with a legal obligation, and so on. There are no many changes here under the Data Protection Act with regards to this type of legal basis. Just be aware that with relation to consent, if you are information society services providing services to children, now the age for consent in the UK is over 13 years old, as opposed to the original 16 years old established in the GDPR. And then if you perform a task carried out in a public interest and you use personal data for that purpose, then this public interest is now further defined under the Data Protection Act. So you would like to check sections 8 and 9 of the Data Protection Act to make sure that you are compliant.
So I understand there's some additional things to consider in relation to special categories of data.
Definitely. So the most important thing here is to make sure that when you process a special category of data, you have considered all the relevant requirements stated in the Data Protection Act. So let's just remember that to process a special category of data or criminal records, in terms of special categories of data, you still need to comply with the condition in Article 6 of the GDPR, and like we said, look at Sections 8 and 9 of the Data Protection Act. And in addition to that, you need to rely on one of the special conditions stated in Article 9 of the GDPR. And now, in addition to that, you need to look at Schedule 1 of the Data Protection Act. So, in terms of the additional requirements in general that you need to look, if you are relying on one of these conditions that are in the current slide you are looking at, you don't need to look at any additional requirement. So this would be if you are already relying on explicit consent or to protect the vital interests of the individuals, you are a religious or political association, or you are using data manifestly made public by the individuals or in relation to legal claims. However, if you are relying on the other conditions, this would be for the purposes of employment, social security, or social protection, because it is in the substantial public interest, related to health or social care, public health, or archiving, research, and statistics purposes, then it is when you definitely need to look at the Data Protection Act.
So you might need some additional documentation as well. So.
Yes, there is one part that is important, and I would say that in practice is what is making an additional change in terms of your compliance plan is this additional documentation that you need to put in place, and this is in Part 4 of Schedule 1, and it applies to some of the conditions that we are talking about. And this is basically putting in place what the Data Protection Act names an appropriate policy document, and also other additional safeguards. So these appropriate policy documents that you need to put in place is in addition to what you have put in place already, and it is one kind of data protection policy, but only dealing with that particular data that you are processing under one of these conditions, Article 9 conditions. And it's just focus on the processing of that data for that purpose, and you need to include things like why you are processing that data, how these specific requirements stated in the Data Protection Act are met in practice in your organization, what retention periods you are applying, and how you have planned to delete that data once the retention period is expired, and also how you are planning to, or you will train the staff for them to be aware of this particular processing. So this is just in a separate and a standalone document that you need to put in place. And also there are other additional safeguards still in Part 4 of the Data Protection Act, and they are actually very related to these appropriate policy documents that we are talking about. And this is to retain this document for 6 months after you stop processing that data for this purpose. So this is kind of for accountability purposes, to have these documents during all these periods, including obviously the 6 months after, available to the ICO if they request for this document to provide this documentation without charge. And also, once you have produced these documents, you need to make sure that this is updated and keep up to date from time to time. So you need to include in the policy a section dealing with how you plan to review, who will be responsible for that, and so on. So let's just look with a little bit more of detail to the most relevant conditions and how these looking at GDPR and Data Protection Act work together. So I am handing out a document that you can find on the Downloads tab. Sorry, I'm just getting back to the previous one. The Downloads tab that you can see at the top of the screen. And this is a document named Legal Grounds for Processing GDPR Data Protection Act. In that document, you can see a more extensive table, including some examples and some tips in order to implement GDPR and Data Protection Act together. So here I'm just bringing a couple of examples to explain how it works. So let's say that I am processing data for the purposes of research. So I know that this is one of the conditions in Article 9, right? But now I know that in addition to that, I need to look at sections 10 or 11 of the Data Protection Act. When I look at that, I am told that a condition in Part 1 of Schedule 1 of the Data Protection Act needs to be met, and I am told that I also need to look at Section 19. So I go there and I check all the requirements. So that basically would be that you can use sensitive personal data for research purposes if the processing is not likely to cause substantial damage or distress to the individuals, if it is not used to take decisions on one particular individual, subject to some exceptions that they are including Section 19 as well, and if it is in the public interest. So otherwise, even though in Article 9 of the GDPR it says that you can use sensitive personal data for research, if you are not able to meet these requirements we are talking about, you would not be able to rely on this condition. So this is how important it is to look at the Data Protection Act, because if you conclude that you wouldn't be able to use this data for research on this basis, then you might need to get back to all the participants and collect consent, for example. So it is really important that you look at this together. And it is exactly the same for the substantial public interest. So it's very important to understand that if you rely on substantial public interest, this is now detailed and defined in the Data Protection Act, meaning we've been seeing clients looking at the Article 9 GDPR and assessing by themselves that I think this is in the substantial public interest, so I'm going to do that. However, now, what is considered substantial public interest is stated in the Data Protection Act, and you need to look at the conditions. So this is in Schedule 1, Part 2 of the Data Protection Act. And again, in the document I'm handing over, you have more details, but basically, let's say that, for example, I am using special category of personal data for the purposes of the prevention of unlawful acts. But in addition to that, this is considered now officially, let's say, under the Act as a substantial public interest purpose. But you need to look at the condition dealing with that particular purpose in the Data Protection Act to make sure that the additional requirements included there are met. Otherwise, again, you need to consider a different approach and relying on different legal basis for that purpose. And kind of the same apply if you use criminal offense data. If you use this for employment purposes, be careful, because the scheme is now a little bit more narrow than historically. Basically, you need to check sections 10 and 11 of the Data Protection Act, and also make sure that if you are processing criminal offense data, you need to meet one of the conditions in Schedule 1 of the Data Protection Act, Parts 1 to 3. And it works practically the same than the other ones.
So what actions, Rocio, need immediate attention when considering the legal grounds for processing?
Right. So basically, obviously, for you to look at having a review of all the legal bases that you are using, look at your data map and make sure that you identify those in need to further input from the Data Protection Act. This will also affect to the record of processing activities if you are under the obligation to comply with Article 30 of the GDPR. It will affect your privacy notice, so make sure that this is in line with what you are telling people that what you do and under what legal basis, and also the relationship with your data processors, because if you put in place one appropriate document, perhaps your data processors need to be aware of that as well. And then the other point that I wanted to just quickly stress is relying on exceptions. So now we've got the exceptions incorporated in Schedules 2 to 4 of the Data Protection Act. Historically, we've seen that not many organizations were relying on the exceptions properly, and the basics is actually saying that what I'm saying for the legal basis. You need to make sure that you read properly the exceptions you want to rely on, and to make sure that you meet all the requirements properly. So let's say, for example, if I want to disclose some information to my legal advisor because it is related to a legal proceeding or future legal proceeding, this is one of the exceptions, but this is not an absolute exception. So under this, the way this works in practice is, for example, if I have details of one of my employees, I can disclose that to my legal advisors based on this exception, because even though I didn't collect that data for that purpose, because this is allowed under this exception. However, the extent to which I can process that data under this exception is only to the extent that it does not prevent me to disclose that data. And this means that I cannot just assume that all the data subject rights are limited by this exception, only if applying these rights prevents me from that disclosure to happen. So if this employee makes a subject access request, responding to that request doesn't affect me to the fact that I want to disclose that data to the legal advisor, and therefore I wouldn't be able to refuse responding to this request based on this exception. I may be able based on different exceptions, but not this one. However, if the employee asks me to delete all the data, then if I delete the data, obviously this would prevent me from disclosing the data to my legal advisor, and therefore I would be able to rely on this exception and make this limitation on this right to be forgotten, to tell the individual that I am not complying with this request because I am relying on this exception.
So we say, what actions need immediate attention when considering the exemptions then?
So just it's kind of easy, just looking at the exceptions that you used to apply under the former Data Protection Act 1998, and then identify which is the equivalent under the new Data Protection Act, and putting the policies in place for the staff to know how to deal with these exceptions. And I think these are the two most relevant points in terms of Data Protection Act that apply to many organizations in general. And another relevant area where we've seen a lot of movements since GDPR are breaches, and now I'm very happy to hand over to Helen, who will cover this part.
Thank you. So in the next 10 to 15 minutes, what we're going to cover is what has changed since 25 May 2018. We'll also look at some recent examples of data breaches, and also talk about dealing with breaches. So what has changed since 25th of May 2018? Well, the ICO has confirmed that there's actually not been that much change in the sectors reporting the greatest number of breaches. So health, education, government, general business, and also solicitors and barristers remain the sectors reporting most breaches. Also, common incident types remain largely the same. The common incident types are lost and stolen data, and emails and faxes to the wrong recipients. 1 in 5 reported breaches involve cyber incidents, with nearly half of those phishing. But what has changed significantly, not surprisingly, is the number of breaches being reported. Lots of reports by telephone, and also lots of reports using the ICO's online form. Now, as I say, perhaps that isn't surprising, given the GDPR was a move towards mandatory reporting. But perhaps this has been exacerbated by some cautious over-reporting, which is something that we'll come on to.
So have you got any statistics and numbers for us, Helen, on how many breaches are now being reported under GDPR?
So in terms of the actual numbers reported, Jocelyn, in March and April this year, so obviously pre-GDPR, the ICO received 398 and 367 reports respectively. In May, the numbers were up to 657, and of course the GDPR came into force on the 25th of May, so there were 7 days at the end of the month when the new laws applied. And then in June, the ICO reported that they actually received 1,792 reports. And more recently, the ICO has confirmed it's still handling around 500 reports per week. So moving on to some recent examples. So Equifax Limited, an example that's been in the news recently. So this all arose out of an incident at Equifax's US parent, which affected 146 million customers. The incident arose between the 13th of May and the 30th of July 2017. And the reason why the ICO in the UK were interested in it is that Equifax's US parent was processing data of up to 15 million UK citizens on Equifax Limited's behalf. Now, the first ICO statement on that particular case was the 8th of September 2017. As I say, it's been in the news again more recently, and that's because on the 20th of September this year, the ICO announced that they were going to fine Equifax Limited on the basis that it had breached 5 out of 8 of the data protection principles, and in particular it had failed to secure personal data, it had poor retention practices, and a lack of legal basis for international transfers. Equifax was fined £500,000, but this of course was a fine under the Data Protection Act 1998, given when the events giving rise to the fine occurred. So that was a maximum fine, although it doesn't give us any insight into what is or what might happen in terms of the ICO taking regulatory action under the GDPR.
So have there been any breaches, Helen, under GDPR that have also been fined under GDPR?
We don't, Jocelyn. We've had lots of further press reports of breaches. Here we've got one, the Dixon's car phone breach. But many of the breaches, like this one, appear to have involved breaches prior to 25 May. So, for example, Dixon's car phone say that the hacking attempt, this allegedly involved 6 million credit card and debit cards plus 10 million data records. It was discovered in June of 2018, but it took place in July 2017. So, assuming that's right, any regulatory action will be under the 1998 Act. So again, won't tell us about the ICO's approach under the GDPR. There's a further example. However, more recently, we have started to see incidents that involve breaches that have occurred post-25 May, and British Airways being one example. So British Airways have said on their website that their recent breach involved theft of data that took place between 21 August and 5 September 2018. So we can expect that to be dealt with under the new law, but it will be apparent from the ICO's first statement in the Equifax case, if you remember that was in September 2017, and then actually when we've seen regulatory action, that was a whole year later, so we shouldn't necessarily expect news anytime soon. In the meantime, what is clear is that the prospects of organisations having to notify breaches and work with the regulator are much greater than ever before, and that's what I'm going to focus on in the remainder of my time. So, some things to think about in terms of immediate response. If you have a potential breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorised disclosure of, or access to personal data. Now, bearing in mind that's a wide definition, the first thing to do is, of course, to begin the initial investigation as soon as possible. the notification obligation being on the data controller, and the data controller having to notify the regulator without undue delay and, if feasible, within that 72-hour deadline after having become aware of the breach, unless it's unlikely to result in a risk to the rights and freedoms of individuals. If the 72 hours isn't feasible, then the data controller must provide a reasoned justification. But that, I would suggest, is territory that data controllers don't want to be in, and they should assume that there will be a reasonably high threshold for them to get over. So when does that 72 hours start? Well, we know from the Article 29 Working Party guidance, it starts when the controller has a reasonable degree of certainty that a data security incident has occurred that has led to personal data being compromised. Now, the guidance does acknowledge that the data controller might initially not be sure, and it acknowledges that the data controller can have a short period of time after having been informed of or detecting an incident to investigate it. And during that time, it won't be considered to be aware, the clock won't be running. However, the objective of that first investigation must be to establish awareness. So, as I said, begin that initial investigation as soon as possible. Otherwise, following the guidance from the Article 29 Working Party, there's a risk that the ICO might find you had awareness and your 72 hours were running when you didn't think they were. And of course, regulatory action can of course be taken for failure to comply with notification obligations. A related point, at the same time, of course, you'll be wanting to contain the breach if there is any possibility of or potential loss of further loss of personal data. And some further things to think about in terms of immediate response, and I'm dealing with these sequentially, but actually they're all things that you should be thinking about as soon as an incident or you think an incident may have arisen. So dig out your incident response plan if you've got one. You may well have spent an awful long time putting this plan together, and it should therefore be helpful to you, so it will be good to have. And secondly, it's also important that if this breach is investigated by the authorities down the line, you'll want to demonstrate that you were following the plans that you've put in place beforehand. Next point, don't forget to notify insurers while you're running around and actually dealing with the incident, because you don't want any notification to insurers to be out of time, and therefore the insurers not to cover the issue when in other circumstances they might have done. Next point, privilege. If you may want the documents that you're creating to be protected by privilege, then you want to start thinking about that early. And in circumstances where you don't actually know quite what's gone on yet, I think privilege is something you should be thinking about. So therefore, involve a lawyer and take legal advice on that.
And then I see you've put up, Helen, assessing risk as one of the immediate things to do when a breach occurs. But at that point, aren't you really thinking about notification?
That's right, Jocelyn. Assessing risk is something that obviously you do when you come on to notification. But it's again important to be thinking about this from the outset as well, so that your response is also proportionate. All these steps that you're going through is also proportionate to the potential risk to individuals from the data breach that's arisen. I'm not going to, for the purposes of this webinar, talk in any detail about how you assess risk. We don't have the time to do so, but the Working Party 29 guidance emphasises the importance of considering likelihood and severity, and also sets out a number of other points and criteria for you to work through. So then when you come on to your notification, some things to think about. Should you use the ICO's telephone hotline, the number being on its website, or should you use its online form? This is one for me where it very much depends on your personal circumstances, I think. The ICO say that around a third of data breaches reported to it are resolved by way of the first call. So that obviously helps the ICO, as there is then no need for follow-up correspondence that would be necessary if those had been reported online. But if you do report by telephone, you should assume that that's going to be treated and recorded as if it's a formal report. Don't necessarily assume you'll be able to have an initial informal conversation. So you should be really prepared for that conversation. And I would recommend preparing answers to all of the questions on the online form, because that will help the call be as efficient as possible and demonstrates you're managing the situation. Of course, also the telephone hotline isn't available all the time, so if you need to make a report out of hours, then that's going to send you down the online form route. If you're going down making a report in writing, should you use your own form or should you use the online form? I am aware a number of clients spent a lot of time putting in place incident response plans prior to the ICO putting their form on the website. So you may well have your very own form for this purpose. What I would suggest is that you use the online form where possible. We know that cooperating with the ICO is important in demonstrating and maybe a factor in any subsequent regulatory action, so make it easy for the ICO in using their online form. But that doesn't mean that you can't use your own form as an additional document, and you can attach that as well. Cautious approach versus over-reporting, something I mentioned at the outset. Because of the potential regulatory penalties for not notifying, there is some sense in erring on the side of caution when assessing whether or not to report a breach. And indeed, that's what the Article 29 Working Party guidance says. However, the ICO has flagged that one of the trends it's seeing is over-reporting, and it warns against this, particularly as organisations become more familiar with the new laws. I would say particular issues to avoid are serial over-reporting, jumping the gun when it comes to lost documents or devices that may be found within the 72 hours reporting window, and also where you're sure you haven't got a breach of confidentiality and there's also no risk to lack of availability. If you're going down the telephone route, avoid busy periods with the ICO. The ICO is openly acknowledging that there are times when its phone lines are busy, especially Friday afternoons. So the key on this is to plan ahead. If you may be reporting a breach late on a Friday, it would be unwise to assume that the ICO's availability will coincide nicely with yours and you'll be able to wrap everything up nicely before the weekend. Better in those circumstances, I would recommend be prepared to file online. Final point on notification. So you can have a phased report, but I think that is a very different thing to an incomplete report. Incomplete reports are to be avoided, and the issue of incomplete reports is something that the ICO has also raised, and this is, I think, over time. Obviously, we're in relatively early days following the GDPR, but I think this is something that we can expect the ICO to start clamping down on, especially where the data breach concerned is significant. So once you've reported what's going to happen next, well, in all cases you will get an acknowledgement from the ICO. You then may get further action in a variety of forms. You may get some further questions on the breach that's arisen, and ultimately you will get a decision from the ICO on the action that they are going to take or may not be taking. There's a sense here that no news is good news, or at least if you don't hear anything too soon, because that means your breach won't be that high up in the ICO's list of priorities. But as I've said, you should still receive an outcome from the ICO at some point, and they've said that that's what will happen. Final point is just to anticipate those next steps, particularly if you think you're making a phased report and you've got further investigations going on. Then it's worth thinking about that when you put in your first report, to try and plan ahead, let the ICO know when you might be in a position to provide more information again, to look like you're managing the situation and try not to end up with being given a deadline that doesn't work into what's achievable your end. So that's data breach reporting to the ICO. Just leaving you here on this slide with, it's obviously a much broader topic, and there are a number of other things to think about that we've not had time to cover in the session today.
And finally, for a bit of a change of perspective, rather than looking backwards over the last 6 months, just very briefly, a look to the future and what might happen when the UK leaves the European Union on the 29th of March next year. Will it affect data protection legislation in this country? On the one hand, no it won't. As Rocio has talked about, the Data Protection Act 2018, that is now in force, and it incorporates the GDPR into our legislation, so we know for certain it will continue to apply in the form it is now in. Of course, looking to the future though, that might diverge and might not be the case. The DPA 2018 incorporates GDPR as it was at the exit date. So if the Europeans take their legislation in one direction going forwards and the UK doesn't make equivalent amendments to its own Data Protection Act, then those two pieces of legislation could end up being differently, but that's a problem for the future and not immediately on Brexit. The DPA also very helpfully tidies up references to other EU legislation when it talks about member states and regulators in other jurisdictions. A lot of legislation is going to have to wait its turn through the Withdrawal Act for government to get around to doing that for a lot of historic legislation, but data protection was actually quite high up the agenda for legislators, and they've done that ahead of time. So on the one hand, no, it won't change. The aspect though where it might change is around international transfers in and out of the UK and the EU. The government has published one of its technical response papers on this topic in amongst its other Brexit no-deal preparation papers, and essentially what that says is that you will be able to send data out of the UK to the EU without needing to jump through any hoops, because we recognise that the EU has a very comprehensive regime for the protection of personal data. Going the other way, it might not be so simple. The government is pushing for either a finding of adequacy, as the Commission has made for other third countries such as Argentina, Israel, Canada, to